Jello again. This is Ben Hitchcock Cross talking to you today. And if I didn't hit the record button, what else would be new? All right. Um, Simple, straightforward one. Let's see if I can do it succinctly this time. It goes like this. I have been at the Stolar versus the Wisconsin Department of Corrections hearing all this last week. Got a couple more to go. It's been a madhouse, a circus, some kind of show, just unbelievable. And the first thing that happened, to be clear, is I walked in and there was a police officer standing there behind me in this tiny little room that supposedly had been invited by the judge. And the judge supposedly always has police officers at all of her in-person hearings. So we'll find out about that if that's true. That's Larissa Benitez Morgan. They're a DWD ALJ. There are some significant issues we're going to have to get into in that hearing. Particularly, the main thing is that the judge's, in my opinion, number one priority is to make sure that nobody records the hearing. Well, we've got some other things that were recorded. And primarily the issue in the headline and everything else is going to be Andrea Olmanson called the Wisconsin Capitol Police and filed a criminal complaint against yours truly, saying that I committed disorderly conduct because I said the things more or less that I'm going to say now to you and make clear to everybody what the issue is. So this is so hot, and we've had this before where you say something that the Department of Corrections doesn't agree with and they go ballistic. Well, as you know, Kevin Carr used to be the secretary of the Department of Corrections, and we'll get Amy Petchacek, all those things. The message here today is thank goodness for cross-examination, particularly his cross-examination, because without that, I think these material falsehoods would have stayed on the record. Now, I tried to depose Kevin Carr back in December. We went through the holiday record, Hanukkah, the judge getting into my religious preferences, all the rest of that. Okay, that's Kevin Carr, that situation. Now, in that decision, the judge ruled that Kevin Carr didn't have anything to do with it and he was a bureaucratic rubber stamp. Now, we knew that was false because we had the Carrie Beyer, among other, and the Swatcher, Jim Swatcher. We had a lot of evidence on the record from Novak that we implored the judge to look at. Judge refused to look at that evidence. Wouldn't look at our links for some reason, but would look at the sworn affidavit from Kevin Carr. Now, it's not my opinion that there's anything necessarily false in the affidavit from Kevin Carr or Amy Petchacek. There may be, I'm not clear on it, but from what I understand, all I know is this. Carrie Beyer said that Kevin Carr was intimately involved in this decision to give, here's the allegation. Correctional Officer Touton, who's still working there, got a 1-day suspension for at a office outing at Lake Emily, a fishing trip, grabbing my client by the breast, lifting her up in front of 30 to 40 of her coworkers, while no one took any action of any kind except later to laugh, and then let her go when she finally wriggled free. Now, I'm sure it wouldn't surprise you to know that only 2 people were willing to come forward with a story that was slightly different than what the 2 people who have sworn under oath have said now. And of the 17 other people, or 15 of 17 people at the Department of Corrections interviewed, including many supervisors who were apparently immediately adjacent to the incident, saw and heard nothing, and told that to the Department of Corrections. Okay, that's all fine. Here's what's not fine, is the lawyers for the Department of Corrections and the Department of Justice went to the judge and told the judge in their argument, essentially, that Kevin Carr knew nothing about this case, had no involvement in this case, has no information for this case. Okay, and I think that is essentially untrue. Now, we'll look at what the judge, because they put it to us, and this is to be clear, what we're going to talk about is Andrea Olmanson writing, we'll just read it out. Okay, but Carrie Beyer, it went something like this. Now, Miss Beyer, when you were part of this decision making on this, how to decide whether or not we should, to discipline the guy who assaulted my client by grabbing her from the breast. You weighed the positives, right? Yeah. You weighed the negatives, right? Okay. You thought about the totality of the circumstances. Yes. You thought about the rules, and you made an intelligent decision. Yes, yes, yes. Okay. Now, how about you work regularly with Kevin Carr? You discussed this with him. You know his decision-making habits, how he works. Now, tell us about Kevin Carr. Did he weigh the pluses? Did he weigh the minuses? Did he make an intelligent decision after looking at the rules and the evidence? Okay. Now, though I'm paraphrasing, but just slightly, that's the evidence that we have. We will have the record, so if I'm wrong, somebody I'm sure can tell me, but that's my recollection of it. Now, I then read this out to the witness, and my understanding is I read these words out to the witness here that I'm going to read to you, and it's my recollection that she said, no, that's not what happened. Now, here is from March 27th of 2024. Dear Attorney Cross, and my name, it says Attorney Benjamin Cross, and to you it's Ben Hitchcock Cross. Let's everybody be clear about that. I have a practicing name that I've chosen, and it's Ben Hitchcock Cross. My guess is that's deliberately wrong because there's 0 for 2 there. But hey, I am in receipt of the request for production that your firm faxed today. Ooh, good one. Reading between the lines, I assume that you intend to subpoena Kevin Carr under under the subpoena statute. As was previously related to you in 2 affidavits, Mr. Carr does not have information for this case. Well, and we'll see, if that part is true or not true. If she's overall being candid, or we'll look, because she's got some argument there. As ALJ Gelhard previously educated you in granting a protective order, as for Kevin Carr, the only piece of information even remotely relevant is that he approved a recommendation of a 1-day suspension as handed down by the management advisory team. Now, bam. Handed down by the management advisory team, straight up contradicted by Carrie Beyer. Now, I think it's Novak 71. I can go look here. Novak 71. That is Carrie Beyer. Some people like links, other people like words. All right. Handed down by the management advisory team. Carrie Beyer is basically the head of the management advisory team. They're a team. It's a process. It's a group effort. Sure. This is nothing more than a bureaucratic rubber stamp for an individual in charge of 9,000 workers. There is no showing that Kevin Carr had any knowledge of this case, which could lead to relevant evidence. Okay, now again, I'm telling you, my understanding, same facts we got from Carrie Beyer and Novak. We just pulled them over. That's why I knew what was going on. And we just pulled him over. So again, Judge Gelhard had, I believe, the correct facts available to him, but chose to make this decision. Now, again, the issue here is when we actually had a hearing and we heard the evidence, it turns out that the decision the judge made ahead of time based on the affidavits of Kevin Carr, Amy Petchacek, and the arguments of the lawyer for the Department of Justice, and his name is Samir Jabber. I've never heard his last name pronounced, but I know it's spelled Jaber. And then we also have Michelle Zacard for the Department of Corrections. They made arguments that got the judge to that point here. Now, an important ethical canon to read as follows is Supreme Court Rules 20.3.4, fairness to opposing counsel, party and counsel. In a pretrial procedure, and a lawyer shall not make a frivolous discovery request or fail to make a reasonably diligent effort to comply with the legally proper discovery request. Okay, that's what she said. She says it's unethical for me to ask Kevin Carr any questions. Now, she tells us that she has viewed my video on YouTube. In that video, you communicate that you believe that you have 2 crucial questions. And I don't think that's half wrong. I mean, I think there's other questions that we need to ask Kevin Carr. But those were the two questions at that time that they were trying to keep us from asking. And then the judge came back and said, there's no evidence other than Kevin Carr's rubber stamp. So again, anybody who watched the Novak hearing will probably have other views than the judge, who heard no other evidence except for the affidavit of Amy Petracek, the affidavit of Kevin Carr, and possibly other things. And but certainly the arguments of those lawyers as indicated. One question that you relate in that video that you desire to direct at Mr. Carr is along the lines of, why was Mr. Toutant only given a 1-day suspension? Now is, I think, extremely relevant for a lot of different reasons. Now, she is going, and this is not wrong, an employee has fairly wide latitude to address the allegations of sexual harassment as the employer sees fit, providing that its actions are reasonably calculated to remedy the situation and prevent further harassment. Bam! Now that's the question that we need to ask Kevin Carr. Hey, Kevin Carr, when you gave him a 1-day suspension, were your actions reasonably calculated to remedy the situation and to prevent further harassment? See, now they're going to assume that this is a fact here, and we're going to see what they're going to say. Aside from the incident at Lake Emily, now that's, again, the allegation there is that Mr. Toutant grabbed my client by her breast from behind in full view of all of their colleagues for about a minute. I guess the one term is got his jollies, which I never has been really clear on how that could be very jolly, but I guess if you're into humiliating people, that might be something. But again, I don't know. Okay. Mr. Stolar experienced no harassment from Mr. Toutant, period. Oh, is that so? Is that so? I say, is that so? The evidence, just as I understand it, is that there were rumors after the event started by Mr. Toutant against that the client heard, and also that people told her that she shouldn't have filed any charges and that she brought it on herself and that Toutant should be protected because his family has a long history with the Department of Corrections. So, it may take that in the reasonably calculated, might take that into account, but you also might take that into account that if he's making rumors about it afterwards and talking negatively about her afterwards, that there was continued harassment. You might feel that way. The evidence might point that way. I don't know. Is it up for the opposing counsel to decide? You tell me. The DOC's investigation of Mr. Toutant and or the suspension clearly remedied Mr. Toutant's behavior. He did not repeat it. Therefore, it would be frivolous for you to pursue a 1-day suspension was insufficient discipline claim. Again, I don't think the evidence comports with that. Critical fact here. Critical fact. Carrie Beyer testified under oath that she met with the attorneys for the Department of Corrections on 2 occasions, one at least for preparation for each hearing, including the one today. Now, they like to watch my YouTube, too. They could also learn that from there. They also conducted this is Andrea Olmanson and Michelle Zakar, because they signed their name to interrogatories, and Michelle Zakar personally told me that she conducted an investigation. So that may be where they're getting this there. Again, and remember the video. If the Wisconsin Department of Corrections says that you are not allowed to come up with an alternate theory, which is what this says. Therefore, it would be frivolous for you to pursue a 1-day suspension was insufficient discipline claim. Since that is a frivolous claim, there would be no justification for you to demand that Kevin Carr answer that question at a deposition. Huh. Okay, I'll keep that in mind. Do you know what just happened? For all y'all old people out there, I am reading this document on paper in the old-fashioned way. and my eyes, which, didn't give the signal to go down the page, I was scrolling with my mouse. Okay. If you don't find that funny, that's just fine with me. That's a world that I can live in. The second purportedly crucial question that you opine in that video that needs to be asked of Kevin Carr at a deposition is harder for me to ascertain given the word salad and run-on sentences throughout the video. I'm going to read that one more time because I think it bears, it's subtle. We'll say it like that. It's very subtle. The second purportedly crucial question that you opine, comma, in that video, comma, that needs to be asked of Mr. Carr at a deposition, comma, is hard for me to ascertain, comma, given the, quote, word salad, close quote, and run-on sentences throughout the video, period. It appears, however, that you wish to ask why Mr. Carr, why Miss Stolar was played on light duty at Central Office rather than at the prison. Why would you possibly think that Kevin Carr would have been involved in that decision? It's going to get better. I'm going to say the evidence at the Novak hearing, just for starters, and the evidence at this hearing, all to back it up. But hey, let's see what her solutions are. So as not to inconvenience Mr. Carr by forcing him to sit at a deposition and or inconvenience me by forcing me to seek another protective order, what I would offer you instead is the opportunity to submit 2 interrogatory questions that I won't count towards the general statutory limit. This is awesome. I propose that instead of wasting all this time, you instead propound these 2 additional questions. All right. Don't complain when your kids come to clean the office, when you pressure them to come clean the office, and then they come to clean the office and interrupt your YouTube. You don't complain is what the message is. All right. I propose wasting all this time. You instead, these two additional interrogatories or something like them designed to elicit the same information regarding the placement at Central Office. Okay. So she is not only offering us 2 free questions, she's going to write them for us. Who was involved in the decision to place your client at DOC Central Office rather than at Dodge Correctional Institution during the period of time that she needed to be placed on light duty? Oh. Why was Miss Stolar placed on DOC Central Office rather than at Dodge Correctional Institution during the period that she needed to be placed on light duty? Oh, that reminds me. I got a third piece of evidence. The client under oath stated that Chrissy Preston, the head of internal affairs, stated, and she stated again at the hearing, that Kevin Carr and Amy Petchacek were both aware of her situation, aware of why she was on light duty, and aware of knew exactly who she was. So, dang it. Testimony under oath versus what an attorney says. Shucks, dang it. If you persist in subpoenaing Mr. Carr for a deposition, please kindly provide sufficient notice that I can schedule a telephone conference with you to discuss this prior to requesting a protective order. All right, and we'll leave the rest of that there for the time being. Now, again, that I think is, in my opinion, that is completely disingenuous for them to make that argument, position, or defense that Kevin Carr has no information about this case, is a rubber stamp. To quote, I think here, what makes this particularly disingenuous is 2 things. I think, again, there's a projection that we're getting to is citing the Supreme Court rule. But I think for when she cites, as ALJ Gelhardt previously educated you, when granting a protective order, I think she's adopting those statements as her own, and she signed her name, albeit electronically, to this. Okay? So, the problem is that under oath. Oh, I even asked Carrie Beyer. I read this sentence out to her, and I said, "Is Kevin Carr nothing more than a bureaucratic red stamp, rubber stamp, by the way?" And Carrie Beyer answered in the negative. And that is what you call the art of cross-examination. I'm not going to claim special powers or anything. I did. It is a known technique to ask them to apply themselves, the standard to themselves, ask them if they did something fair, they wouldn't do something unfair, they thought, and then go to their boss. That's a known technique, fine, great. But we knew we knew what the answer was ahead of time. So assuming she's not going to lie, we're not, yeah. So you tell me, based on what we read, please in the comments, please add the likes, please do all the things that I really despise even bothering with, because this is a nerd channel for nerds. Here, thank you so much, and their friends, and my original pal wishers. But you see what I'm saying? This is a safe space for these kind of people. We don't go around begging for these things. What are we, children here? Okay. So, this discussion that I'm having with you, and let's be clear, we'll have the recording, but somewhat more forcefully, is the result of which, when they heard it out loud, Andrew Olmanson called the Capitol Police and made a criminal complaint against yours truly for disorderly conduct. So that's the setup. Ladies and gentlemen, I'm sure we'll have more. Thanks for sticking with us. We'll keep you informed.